With that being said, let's head on over to our important community personalities for this week. The first one being Attorney Ramesh Khurana of the Khurana Law Firm, located in the heart of Gaithersburg, Maryland. Attorney Khurana will be accompanied by Attorney Kenneth Haber, also from Maryland. Attorney Haber is also the former assistant of U.S. Attorney. Today on this set, Attorney Haber has a whole string of questions on immigration for Attorney Khurana. Let's hear this question and answer session in their segment called Business and High-Tech Immigration Law.
Good morning. My name is Kenneth Haber. I'm a former assistant United States attorney and a former senior attorney from the United States Department of Health and Human Services Office of Inspector General. Today, we're here on the Capitol Forum, and we're pleased to have with us Ramesh Khurana, a well-known immigration attorney who's here to shed some light upon some of the more complicated areas of immigration law. Welcome, Ramesh.
Thank you very much.
Ramesh, I understand we're going to be talking about the EB-1C visa and the L1A visa and what the differences are. Can you please explain the two different types of visas?
Yeah, Ken, I'll be most pleased to do that. First of all, I want to thank you for inviting me to the studios, and I always enjoy your questions. So this question is of paramount importance to managers and executives who are working for different businesses, and they come on transfers from parents or subsidiary or affiliate establishment from overseas. So this EB-1 program and L1 program are meant for those kinds of managers and executives, and also for people with specialized knowledge. When we are talking about EB-1C category, now this category basically pertains to the green card process for managers and executives or people with specialized knowledge. Under EB-1C category, you have to be either present here or even while you are sitting overseas. EB-1C green card process can be started. People don't have to go through even obtaining L1 if that's the way employer wants it. And when we are talking about L1, this is just a kind of non-immigrant visa like H-1B. You come here temporarily and for certain period. So this is of two types. One is L1A. Under L1A, the maximum period is 7 years. And under L1B, the maximum period is 5 years. So L1 is non-immigrant, EB-1C is an immigrant visa or green card.
Which one would you recommend for a startup business?
When you say that which one I would recommend for startup business, of course, if a person qualifies based on certain criteria, L1A, let us say a person has been working as an executive or manager in the overseas office, and the condition is the person must have worked at least for 1 out of last 3 years. That's the prerequisite. And if it is a managerial or executive category, then we can file L1A, because L1A has a certain advantage over L1B. Because if a person is on L1A here and he also worked as manager or executive, which is properly documented, then you can file the green card petition right away. But the office must have been established for a period of 1 year before you can file the green card. Sometimes, people come to open a new office of the parent company in India or Pakistan or subsidiary company, it all depends. And if you have been doing business in the United States for a period of 1 year, then you become eligible to file for the green card petition.
Very good. What does it mean that a person has executive capacities, an executive employee, in order to be able to transfer to the United States?
Ken, as I said, there are two types of managerial categories, executive category and managerial category. Under executive category, basically you are taking care of the top level functions of an establishment or organization. like what we call is you are planning, you are preparing the business forecast, or you are directing the business. So when you use these kinds of buzzwords, planning, directing, and preparing the policies and procedures, and this person has a wide latitude in the discretionary authority. This person receives no guidance from anybody, except he communicates with the board of directors. So that is the executive capacity. And when we are talking about the managerial capacity, and that could be basically a functional manager, and he has the authority to hire and fire managers. So again, you can come under L1A only if you are holding a top level managerial position and you are communicating through the lower level employees through another manager. Otherwise, USCIS will come back and say this is not a managerial position because you are interacting direct with the sport level staff. So that's the catch.
I see. Does the business that's filing for this status have to get a Labor Department certificate?
Again, it depends whether we are talking about L1A visa or L1B. Under L1B, there is a requirement of the labor certification process, but for L1A, there is no labor certification requirement. Again, as this is meant only for senior executives and managers. So it comes under the EB-1 category. Under the EB-1 category, the priority date is current. So you are standing again on the top of the queue as there are limited green card numbers. So your priority date is current at this point. Even for nationals of India and China, whose priority dates always languish, sometimes they have to wait for 10, 11 years. But in case of EB-1C category for L1A people, there is no wait. There is no wait for managers and executives. You can straightaway file a package which would say adjustment of status along with the immigrant petition.
Very good. What evidence does a petitioner have to produce for obtaining these statuses?
There are three important components when we are talking about EB-1C green card process. One is your overseas company. It maybe it's a subsidiary or it's a parent company or an affiliate. So that's one component. So that's the lifeline of your establishment in the United States. So this parent subsidiary has to be alive and must be doing business. This is very important, doing business. That means they are still providing services or producing products. And as I said, the fundamental thing is a person has been transferred from, let's say a person is coming from India, from Indian subsidiary or parent company or affiliate to the United States. If that very particular subsidiary or parent is no longer in business, this company which has been set up here loses the eligibility criteria for the purpose of L1 or EB-1C category. So one is proving that that company is still in business or doing business. Then you are talking about the business in the United States, that this company is in business. You provide all those kinds of documentation. What if the licenses are applicable to that kind of business? You enclose the copies of the licenses. You enclose the copy of the lease for the office, where the office is located. You enclose your certain invoices, sale and purchase invoices if you are providing some services. And if you are advertising in some trade journals, please enclose those copies as well. You know, this is the burden of persuasion on the petitioner. Provide as much evidence as possible. Abundance of evidence is always helpful, but make sure that's the relevant documentation, not the irrelevant one. That is always appreciated. And as I said, there are three components, and the third component is the employee or the executive or the manager. So you have to talk about that employee, that he worked overseas for a period of 1 year out of last 3 years, because that's the prerequisite. And then if you are filing EB-1C under the executive or managerial category, then you have to provide an evidence to show that this person was performing executive or managerial duties while he was in overseas office as well. So once you have talked about these three important components that make the petition a winning proposal, and I am sure that's likely to be approved by the USCIS.
That's very good to hear that there's ways that people who are highly qualified can get here. Multiple ways, obviously. What about their spouse and their children who are unmarried under 21? What's the procedure for them to get over here and take up residency?
Sure. When we are talking about the spouse and children under 21, the answer is they are covered and they are issued L2 visa. If the petition has been filed from here and all the family members are here, then along with the petition for the principal beneficiary, you can file for the spouse and the children, and they are called derivative beneficiaries. And the good thing is the spouse gets the green card, and children under 21 also get the green cards. So only children above 21 they don't get.
Is there some other way a child over 21, although he's not a child, but he could be living with the parents? In some cultures, children stay with their family until they're married, especially women. Is there some way a woman could come over if she's over 21 and unmarried yet?
As regards children are concerned, if they are over 21, they miss the bus.
Wow.
So they are on their own. If they have to find some acceptable mode of coming to the United States, getting married, there are different kinds of visas available, maybe H-1B or exceptional ability, extraordinary ability, or maybe children over 21, they are working with some companies, or they are from Canada and Mexico, there is a TN visa available depending upon the job offer. So there are different routes which can be used by children over 21, but they won't get the benefit of their parents' situation being as derivative beneficiaries. They can't.
Is there any reason why they cut it off at 21 when, it really seems a little discriminatory? I can understand a male because he's going off into the job market, but so many times females are literally tied to their parents. Is there any reason why they make it a 21-year age?
This is based on the immigration-related regulations, and I think most of the immigration benefit applications, they provide benefit to children only under 21. They become adults and they are on their own. Yeah.
Sounds pretty harsh for some nationals where their children stay with them for an extended period of time.
Yeah, but I think up to the age of 21, I think beyond that they grow up and they should stand on their own feet. I know there is one exception I find under G4 visa when the people come to work for the international organization. Yeah, they can be accommodated about 21, but not under any other type, whether L's or H's or E's. No, they are not covered.
Well, thank you very, very much. And do you have a real quick word for the television
sure,
audience?
I'll be happy to do that. In my practice, I have seen that people try to obtain green card through the EB-5 process, like investing $1 million or $500,000. Now, which is a very cumbersome process, and still it may take about a year or so for the approval of your petition. And the most important question under EB-5 is the legitimacy of the funds, which becomes very difficult for most of the applicants from India, Pakistan, these kinds of nationalities. So I think L1 route is the most appropriate one. You can come and establish your office and then apply for green card.
Thank you very, very much.
Thank you, Ken. I appreciate your inviting me here.
My pleasure.